So without any further, there we go, we're recording. I'll pass over to Stephanie now and you can take it away.
Thanks very much, Victoria. Good afternoon, everyone. Thank you for joining. So if you've been to any of these talks before that Brodies have done, they usually follow a bit of a theme, but we thought that it would be good to do a bit more of a variety of topics just based on case law that's come out in the past year that we think is important for designers and contract administrators to be aware of. And then another huge topical issue at the moment is also materials shortages and price increases in the industry. So we'll have a section at the end dealing with how construction contracts might respond to that, and then what you would need to know as a contract administrator if claims like that come across your desk. So I'll start off by going through the legal developments that have occurred in the past year that I think are important for contract administrators to be aware of. Then I'll go through similarly key cases that designers should be aware of, and then Manus, I'll pass over to Manus Quigg, my colleague, who will go through how construction contracts might respond to material shortages and price increases. So kicking off then with legal developments that are important for contract administrators to be aware of. The first case that I've selected is this case, Downs Road Development. Now, this case concerned an interim application for payment in the sum of £1.8 million. And by way of a brief reminder on payment mechanisms in construction contracts, as I'm sure you'll be aware, it's a very rigid process whereby if a payment notice or a pay less notice isn't issued timely or validly, then the sum applied for in the application from the contractor will be found due and there's no defence to non-payment. So in this case, the employer did issue a payment notice on time, but that payment notice only stated that £1 was due, so 97 pence once retention was deducted off. And the covering email to the notice had said that the employer would be issuing in effect a further notice once they'd had an opportunity to review the application in more detail. So as promised, the employer did issue a further notice 6 days later, stating that £657,000 was due, and that was the sum that was paid on the final date for payment. So the employer had followed that pattern in previous payment cycles because they said that the contractor's applications for payment were difficult to follow, accompanied by substantive detail, and they simply just didn't have enough time by the deadline for the payment notice to review those in full. So it would just issue a holding response effectively. But the contractor challenged that payment notice that they issued by the deadline, the one that said that only 97 pence was due, on the basis that it couldn't be considered valid given that they ultimately considered £600,000 odd was due. And the court agreed with the contractor on that. The court had said that the payment notice that was issued in the first instance could not realistically be said to accurately state the sum that the employer thought was due. And that was clear by the fact that they'd issued a further notice stating that significantly more sums were due. And in coming to that decision, the court relied on the well-known test within the kind of construction payment legislation in this area, the Housing Grants, Construction and Regeneration Act 1996, which said that payment notices need to provide an adequate agenda for adjudication. By that, we mean that they need to set out what's in dispute between the parties on payment and confirm to the adjudicator effectively what they need to decide on. So by the employer just issuing a payment notice for 97 pence, it wasn't accompanied by any basis of calculation or reasoning, and then issuing a further notice in significantly more sums, it couldn't be said that that first notice provided an adequate agenda for adjudication. It wasn't something representing the employer's genuine belief in the sum due. And it's that genuine belief in the sum due concept that's interesting, because it could be said that this decision is kind of including a new line of attack on the validity of a payment notice, testing the employer's subjective intent and what they're stating is due. But contractors and subcontractors obviously need to be careful not to stretch that reasoning too far, because in this decision, the court was also influenced by the fact that the employer admitted that they were going to serve a subsequent notice, and they also hadn't provided a basis of calculation as to how they got to the point that an extra £1 was due. So the lack of a basis of calculation in itself would have invalidated the notice. So contractors, subcontractors were saying needs to be careful not to stretch that reasoning too far. And from a contract administrator's perspective, obviously the clear message from that case is that any kind of certificates, payment notices, pay less notices issued needs to be setting out a clear agenda for adjudication. You can't get away with just issuing holding responses in the hope that any subsequent notices might be valid. The claim could just rise or fall on that first notice, and if it isn't valid, then it obviously creates a gateway to what we call smash and grab adjudications, where the contractor can just claim the full amount sought in their application. So moving on then to the second contract administration case I thought was quite interesting. So this is the case of Triple Point, and this concerns liquidated damages. And in this case, the courts were going back and forth on whether or not liquidated damages would still be due for payment in spite of an employer terminating a contractor's appointment. So the subject matter of this one concerned provision of a software system. So it wasn't a construction contract, but the principles in this case would equally apply to a construction contract. And as you'll know, liquidated damages provisions are common in construction contracts. So the court that heard this case in the first instance had found that albeit the employer had terminated the contractor's appointment, they'd still had an accrued right to the liquidated damages up to the point of the contractor's delay. So that claim was protected in spite of the fact that they then terminated their appointment. But the Court of Appeal came to a different view, and controversially had said that the wording in the contract provided for liquidated damages to apply up to the point that the employer accepts the contractor's works. So in this case, they obviously hadn't accepted the contractor's works because they'd terminated them. So on that basis, the right to liquidated damages fell away entirely. So the employer took their case even further. They went to the Supreme Court, and the Supreme Court agreed with the employer and the first instance court. It had said that unless there are clear words in the contract which provides that the right to liquidated damages falls away on termination, then that right is protected. Obviously, it'll be only there up to the point of termination, and thereafter the employer would just need to assess their damages in the normal way. They're not going to get a fixed weekly or monthly amount. And the court had said that the reason why the liquidated damages provision needed to be protected in these circumstances was because it reflects the commercial reality of why these clauses are needed. They're there to avoid the employer having to go through what can be quite a time-consuming and difficult task of assessing their actual losses and giving them the certainty of having a fixed amount per week, per month. So to remove that claim entirely, the Supreme Court had said what the Court of Session was, Court of Appeal, apologies, were effectively doing was throwing the baby out with the bathwater. And another important point that the court had made is that if it was the case that liquidated damages provision fell away on termination, you could find contractors and subcontractors trying to engineer a scenario where they get their appointment terminated to avoid the consequences of LDs. So the reason I mentioned that case is obviously as contract administrators, you need to be alive to how the courts are dealing with key contractual provisions, and liquidated damages is a big one, especially in the market as it is now, as Manus will go on to discuss, where we are seeing that contractors are struggling to deliver projects due to cost rises and shortages of resources. So you could be finding yourself in a scenario where you're having to deal with a contractor termination. So it's just important to know where your client is employer, their rights lie in those circumstances. So the next case on contract administration, the last one before I flip on to cases for designers to be aware of, is this case of CC Construction. So here the parties had entered into a design and build contract for a new build house, and the contractor had issued a final statement at the end of the project in the sum of £483,000 on the 1st of December 2020. the employer wrote to the contractor on the 18th of December 2020 disputing that final statement, and they didn't pay the sum claimed. So the contractor went off to adjudication, and the adjudicator had to determine whether or not the employer had effectively done enough to prevent that final statement from becoming final and binding. So I'm sure you've seen reference to the JCT SBCC standard clauses that provide that if a final statement isn't effectively challenged, it becomes conclusive. So as I said, the adjudicator had to determine whether or not the employer had protected themselves in that regard. And the adjudicator found that the employer hadn't done enough to challenge that final statement. So the employer had to go to court to try and, the contractor went to court to enforce the adjudicator's decision on that, and then the employer defended it on the basis that they thought they had done enough to challenge that statement. And as a kind of preliminary issue that the court had to determine, which an interesting kind of point of law came out of, was when the due date for that final statement was. So you might be aware that the JCT SBCC contract kind of provides a mechanism for determining the due date of a final statement, and it's a month later than 3 different events, depending on which one occurs last. So those are the end of the rectification period, the issue of a certificate of making good defects, and the date of submission of the final statement. So on the certificate of making good defects mechanism, the way that works is the contract administrator needs to issue a schedule of defects that the contractor needs to rectify, and those need to be rectified. That schedule needs to be issued no later than 14 days after the rectification period. And once those defects are rectified, they can issue a certificate of making good defects. So in this case, the employer had issued a certificate of making good defects on the 13th of January 2021, so about a month and a half after the final statement had been issued. So the employer was looking to effectively push out the due date for that final statement until it had issued its certificate of making good defects, really to kind of buy itself more time. But the court had found that because the employer hadn't actually issued a schedule of defects that it wanted to be made good, there was no scope for it to have issued a certificate of making good defects. And what that meant was that trigger as part of the final statement due date determination process fell away, leaving you with either the end of the rectification period or the date that the final statement was issued. And in this case, the court had found that the final statement was the last date of those 2. So that determined when the due date for the final payment was going to be. So going back to the kind of initial question I mentioned, as for whether or not the employer had effectively challenged the final statement by issuing a letter on the 18th of December in response, what the contractor was saying that no, that wasn't sufficient, because the contract also provides for final statements to be challenged by way of formal proceedings, being adjudication, arbitration, or court. All the employer had done was issue a notice, and that wasn't sufficient. It had to also raise formal proceedings. But what the court had said was that the employer didn't have to do both, it could do either. So because it had issued a notice in response to the final statement, that was sufficient. It wasn't also required to commence formal proceedings. And that's quite an interesting finding, because I'm sure a lot of practitioners, lawyers, contract administrators who've dealt with these standard form clauses have gone on the basis that employer would need to raise formal proceedings in order to challenge these final statements. And I don't know, given that is thinking in the industry, whether or not anyone would be willing to rely on this decision alone to say that that isn't required and it's enough for a letter to have been issued in response to avoid the statement becoming binding. But I suppose at least this case offers a lifeline if it's the case that all the employer has done is issued a letter and they've not managed to commence formal proceedings. So moving on now to cases that I thought were quite useful for designers to be aware of. So the first one here is the case of BDW Trading, and that concerned a dispute between a developer and an engineer in connection with the structural design for high-rise flats. So while the developer was carrying out investigations on its cladding as a result of Grenfell, it found that there was significant cracking in the structural slab of the building, and the cracking was so severe that the building was deemed unsafe and had to be evacuated. So BDW sued the engineer URS for damages, and included in that damages claim was harm to its reputation. It called it reputational loss. So the court had to consider whether in this scenario a structural engineer would be liable for paying damages for a developer's harm to their reputation. So there's a long line of case law that deals with what kind of losses a negligent professional is liable to contribute for as a result of their negligent advice or breach of contract. And what the courts have been careful to maintain is that there could be a duty owed to someone to not provide negligent advice. But if you do, that doesn't necessarily mean that you're going to be liable for all of the losses that that person has suffered. So in this particular case, the court found that an engineer wouldn't be liable for reputational damage. The reason being was that that is not a damage that can easily be quantified. So it's something that might cause engineers or other professionals to find it difficult to get professional indemnity insurance if you're effectively looking at a blank check type of loss that needs to be covered and protected by the insurance. And related to that point, they'd also said that it could be eye-watering sums that you could be claimed against you, because it just depends on what reputation that developer's been able to build up before the issue that has been said to harm their reputation has occurred. So I suppose the key message from this case is that it serves as a good example of how claimants pursuers are going to try and stretch their damages claim as far as they can against designers when something's gone wrong, which is why we say to designers, try as far as possible to at least have a cap on liability in your appointment, and even better, try and agree provisions that certain types of losses will not be recoverable, for example, consequential losses such as reputational damage. So actually the key message from that case. So the next case I wanted to discuss was this one, multiplex construction against Bathgate realisations. So the facts of this case concerned Multiplex's appointment of Bathgate as a concrete subcontractor as part of the huge 100 Bishopsgate development in London. So the works included the construction of a slip-form rig, which is a piece of temporary kit that effectively allows the contractor to pour the concrete floors of the building incrementally, and then the rig just moves up the building as that occurs. So Bathgate had appointed a designer to design the slip-form rig, and it also appointed a third-party checker to provide a Category 3 certificate, which was required as part of the building standards. So the Category 3 checker didn't have any contractual link with Multiplex, it was just with Bathgate. It provided its Cat 3 certificate to Bathgate, who then amended it and sent it on to Multiplex, but the certificate did say, in spite of the amendments, that the checks had been carried out with reasonable skill and care. So Bathgate subsequently went into administration, and that meant that Multiplex had to appoint an alternative subcontractor, Byrne Brothers, to complete their works. So when Byrne were carrying out their checks on this slip-form rig, they found that it was defective, so much so that it was unsafe and could not be used. So Multiplex spent £12 million on remedial works and associated losses in order to deal with the defects in that slip-form rig. Now, the problem that Multiplex had is Bathgate were in administration, as I've said. Their designer didn't actually have any, Bathgate's designer didn't have any insurance cover. So its only route was against the Category 3 checker. Now, the Category 3 checker had also gone into liquidation, but it did have insurance cover, which meant that its insurers could effectively respond in its place to this claim. So, as I said, Multiplex didn't have any contractual link with the Cat 3 checker, but what it was trying to argue was that it owed a duty of care to Multiplex nonetheless to carry out its design checks with reasonable skill and care. Multiplex had said that the checker knew that its certificate would be relied on by Multiplex, so it assumed a responsibility to them to ensure that the answer that it gave was right. Now, as mentioned before, there's a long line of authorities on kind of what sort of duties professionals owe in certain circumstances and what kind of losses they are liable to pay for if they give negligent advice. So those authorities are clear that you don't need to have a contract with someone in order to owe them a duty of care, which can obviously be a hazardous area for designers if you find yourself giving advice or providing documents that are relied on by third parties that you're not in contract with. Certificates in particular can attract claims of this nature because that certificate could be issued, but then to an extent it goes out of your control in terms of who ends up relying on it. So the court had to analyse the law on this very carefully, given the huge sums at stake and the fact that there wasn't a contractual link there between Multiplex and the checker. So the court did hear expert evidence on the purpose of this Cat 3 check, and it was clear that this is a certificate that the checker would have known would have been relied upon. But the court was clear that that liability was just to Bathgate, it wasn't to Multiplex. There was no contract with Multiplex. There wasn't even any communications with Multiplex prior to this certificate being issued. And another factor that the court thought was particularly important was that, like in a lot of construction projects, there was a complex contractual arrangement here between the various parties thought had gone into setting up this structure. There was no contractual link there between Multiplex and the checker as part of that structure. So Multiplex couldn't just use the law to try and short circuit that contractual arrangement. And another key consideration for the court is that it wasn't as if they were dealing with a gap in liability where Bathgate wouldn't have been liable to Multiplex. The only problem was Bathgate couldn't pay, and that was Multiplex's real issue. There was no liability gap there that the court had to protect against. Another point that was helpful to the checker here was that the wording in their contract provided for their services not to be relied upon by third parties. So wording to that effect is obviously going to be important to have in your appointment agreements. But obviously, if you act inconsistently with that and provide documents and advice to third parties, then that wording might not protect you. So overall, the designer was very lucky in this, well, the designer's insurers was very lucky, or the checker's insurers was very lucky in this case, and that they managed to demonstrate that the duty of care wasn't owed to Multiplex as a result of their category 3 checks. But obviously it's a useful case to keep in mind of the risks that can occur if you do find yourself providing, as I said, documents or advice to third parties. You can't just rely on the fact that you don't have a contract with them to avoid liability if you turn out to have given negligent advice. So the second last designer case I wanted to chat through was this one, Mott MacDonald against Trant Engineering. So Trant Engineering was a contractor and it had appointed Mott MacDonald as its designer in connection with a £55 million power station in the Falkland Islands. So the parties had entered into dispute pretty quickly at the start of this project, so much so that they actually had to enter into a settlement agreement in order to map the route forward in trying to get this project completed. And part of that settlement agreement included clauses restricting and limiting Mott MacDonald's liability to the contractor, and it included a £500,000 cap on their liability. Now, the parties entered into dispute again. Mott MacDonald, it said, weren't being paid by the contractor unjustifiably. So in return, it stopped providing its services to the contractor. It revoked their access to their BIM model and their design calculations, such that Trant had to go and appoint another designer to effectively redo the design, and that cost them £5 million. So obviously Mott MacDonald had said, well, no, I'm only liable to you up to a cap of £500,000. That's what's been agreed in our appointment. But what Trant were saying that was because the breaches on Mott MacDonald's part were willful and deliberate, the cap on liability wouldn't apply in that scenario. So the court had to look at the context of this breach and whether or not Mott MacDonald could still claim that it was protected by that cap on liability. So the court sided with Mott MacDonald. It said that the wording of the clause was fairly clear. The cap applied to breaches. It didn't carve out any particular type of breaches to say that, for example, deliberate, wrongful, willful breaches would not be covered. So it was fairly plain that the cap would apply in this circumstance. And also that's something that Mott MacDonald would have been, Trant would have been aware of when it signed up to that clause. So Mott MacDonald managed to convince the court that they had the protection of that cap on liability and avoided paying a significant additional sum in damages as a result of the dispute that they'd entered into. So the takeaway from this case is obviously not to breach your contract so terribly that someone's going to try and argue that the provisions of it don't apply. But it just serves as a useful reminder of how helpful clauses which restrict or limit your liability can be. And not only that, being wary of any attempts to try and carve out certain types of breaches from those limitations on liability, as is what Trant should have done in this case if it wanted the protection. So just be wary of that and be alive to that when appointments are getting negotiated. So the last case I am going to discuss before I pass over to Manus is clues in the name. It is an appeal from an arbitrator's decision to the court. So the losing party effectively thought that the arbitrator got his decision wrong, so asked the court for a different answer effectively. So the facts of this case concerned a contract between a contractor and designer for the rehabilitation, design in connection with the rehabilitation of a water main system. Now, the works included the use of a polyurethane lining material to coat the inside of the pipes, which subsequently failed. Now, that lining material was actually specified by the contractor, not the designer, prior to the designer's involvement. So the designer had said, well, I'm not liable for the failure of that material. That was your specification, contractor. And the arbitrator looked at the wording of the designer's appointment and had found that the designer was responsible. In effect, they had assumed responsibility for the contractor's design. So the designer obviously didn't agree with that, asked the court for a different decision, and the court looked at the relevant provisions of the contract and noted two in particular that had said, first of all, that the designer was deemed to have provided for any design works necessary to provide a complete design for the project, and another clause which said that they also had deemed to have responsibility of anything noted as being a contractor's design portion in the scope. So according to the contractor, obviously that passed on full responsibility to the designer for its specification, and the court agreed with the contractor on that. It said that the wording of the contract was plain. These were what we call deeming provisions, whereby the designer was deemed to have taken on the design responsibility for the contractor's design. And the court thought that it would have been clear to the designer that that's what it was signing up to. So responsibility, unfortunately for them, ultimately stopped with them. So the takeaway from that case is, obviously, if you're in a kind of a pre-appointment scenario where the appointment's being negotiated, watch out for any provisions that provide that you have deemed to take on design responsibility for other people's design work effectively. Is that something that you're willing to take on? Have you checked the accuracy of that design work, or is that something that you would need to push back on? Alternatively, if you're in a scenario where that's already been signed up to and the deeming provisions are there and there's other design work carried out by the contractor, for example, as early as possible, check that design work if you can, because if there are any problems with it, generally speaking, the earlier issues such as that are flagged up, the better. So that's my piece. So I'll pass on to Manus now, who's going to talk about the materials shortages and price increases issues we're seeing at the moment.
Thanks very much, Stephanie.
Nice.
The purpose of this talk is to cover off the sort of the issues that we're seeing at the moment and some thoughts on how the standard form contracts, I think the one that you're most that you use most or are most comfortable with as the SBCC form of contract. So what's the problem? Well, first of all, significant price increases. I'm sure you'll all be aware of that. Extended lead-in times for materials result in delays to projects. We're getting asked on not a daily basis, but certainly a number of times a week, you're getting asked what entitlement the contractor would have to additional cost because of the increase in materials. The most significant one we have at the moment, Steph and I are working on, is a school where the price of the glue lamp structure has gone up by £750,000 on a contract that was started out at 1.3 million. So it's a big problem at the moment. We're also hearing stories of contractors that are going into insolvency because they can't carry the additional cost. The additional cost of the materials and the projects they're trying to deliver. We're also hearing of contractors just walking away from projects and just saying, sue me, because I just can't afford. I'm going to either go bust or they go bust or you just have to accept the fact the contract's at an end and you're just going to have to pay more. So that's the sort of arguments we're hearing. We're also seeing a significant shortage of skilled labour. For whatever reason, there is a shortage of skilled labour at the moment in the market at all levels. And clients would complain about access to good skilled labour as well. That is a problem. So why have we got this problem? Well, we call it a perfect storm. You have COVID, which definitely has impacted. Brexit has definitely impacted. You've got a housing boom at the minute, market recovery, and supplier opportunism, i.e. I can charge more just because supply and demand. So which leads to two interesting legal issues. One is entitlement. What entitlement is there to more money under the contract? And if you're a contract administrator, you're going to have to guard this pretty carefully and keep an eye on what the contract allows and doesn't allow. But secondly, causation is what exactly is driving this at the moment. And that's the more interesting point, because no one can really successfully argue. We all know as a matter of fact the prices have gone up, but can we actually say definitely why? Now, looking at the contract, first of all, we've got the SBCC Design and Build 2016, one of the most common forms in use at the moment. And if you look at clause 221, what it says in relation to materials, if they're described in the employer's requirements or the contractor's proposals or the other contractor's design documents, then you need the employer's consent to substitute any materials. So effectively, if you're the contract administrator looking at it from the architect's point of view, there's going to be the employer's consent is needed before you can swap out any specification for what is available, what is available at a reasonable cost. Relevant events, so time, extensions of time, and there are under SBCC there are very limited routes to recover more time or more money for materials. It's a bit like the COVID situation, where if you have an instruction, that is your cast iron guarantee. But aside from that, if you don't have an instruction for a change, you're in difficulties if you're a contractor. So there are very few that will assist a contractor in relation to delays caused materials, but the most likely ones are 226.1, and that's if the delayed materials are required as a consequence of an instructed change, then that delay can be recovered. So if the employer effectively just gives an instruction because he wants something different, or he just gives an instruction because he accepts that something isn't available, that would be a relevant event. 226.12 is if the delay in the supply of materials is caused by the exercise of a statutory power after the base date, then that's a relevant event. It's a theoretical entitlement. I'm not sure that we would actually be able to prove that there's any shortage of material caused by the exercise of a statutory power by a government. I suppose it's quite interesting. We'll be interested to see whether some of the embargoes that are in place at the moment as a result of what's happening in Ukraine at the moment, whether any of those are going to impact on the supply of materials and whether that's as a result of the exercise of a statutory power. But looking at matters as they stand today, difficult to see. But it does highlight, as we say there in the slide, the importance of agreeing an appropriate base date in a contract, because that's your benchmark to measure change against. And the third one is 226.14, and that's a result of a force majeure. Now let's just start with talking about what a force majeure is. A force majeure is something that's unforeseeable, that's beyond the control of both parties, and couldn't have been anticipated at the time when the contract was entered into. COVID is a force majeure, or was a force majeure, but there comes a point in time when if you're entered into a contract really after February 2020, in all probability, there's just no longer a force majeure, because you would have known it was there. You would have known from the media hype that it was probably going to impact on contracts, and something that parties could have foreseen. So it was relevant up to a point in time, but after that, it probably isn't. And after that stage, that's whenever we started to see COVID clauses coming into contracts. So the only other way around it is if an earlier relevant event has pushed the project into a period where labour and material availability has become an issue, then the contractors can seek an extension of time against those earlier relevant events. That's what we would call the winter working principle. You know, if it hadn't been for the instructed variation, I would have finished all my work in September, but as a result, I'm now finishing it in March, and it's taken me so much longer because the daylight hours are shorter, because the weather's worse, and as a result, I've had to incur all these additional costs, and it's taken longer. That's that kind of principle. So if an earlier entitlement pushes you into a period where something else happens, well, then you can claim your entitlement under that earlier relevant event. So that all requires careful consideration of the programme, when materials are required, when materials should have been ordered. And Steph and I have a case at the moment where the big argument is, yes, we accept as a matter of fact that the cost went up, but when should you have fixed it? When should you, the contractor, have entered into a subcontract which involves the purchase of those materials? And the early purchasing of materials and the fixing of price is something that we'll be speaking about through this talk. So, and causation is a big one. Causation is interesting, even through COVID and material shortages alike. If you think about it, the one thing that's impossible to prove is what exactly is causing the delays. So if you take a hard line and say, prove it, it's difficult. The only thing people know is, as a matter of fact, there is a shortage of materials and the price has gone up. Relevant matters, now remember, relevant events give you time, relevant matters give you money. There are far more relevant events than there are relevant matters. So it's easier under an SPCC contract to get time and relief from liquidated damages than it is to get actual money. And that's definitely the case when it comes to materials. So loss and expense can be sought for, realistically, it's only going to be, again, that's the change. It's 421(1). If delayed materials are required as a consequence of an instructed change, then the loss and expense caused by the delay can be recovered through that change instruction. Now, you need to watch as contract administrators, because if you think about it, that's the easiest route to get time. It's also the easiest route to get money. So if you issue an instruction without any basis for a change, effectively you are giving time and money to a contractor, and that could potentially be a breach of contract on your part, because you've given entitlement that's difficult to challenge to a party that's not really due it under the contract. Alternatively, it may be that your client wants to give relief, and we'll come on to that in a minute as to why that might be the case. So as a general point, again, is winter working, again, if earlier relevant matters have pushed the project, earlier delay events, which would of themselves be relevant matters. So an earlier change, for example, pushed the project into a period when materials then becomes a difficulty, then you would argue perhaps under that relevant matter. Next one, please, if you don't mind, Stephanie. And it's right, other considerations. So number one is, if you take this is I'll repeat to you what happened during COVID. The discussion with clients, with developers, was, yes, you have passed the risk for COVID successfully down onto the main contractor, and because they're a tier 1, they would have passed it on to the tier 2 subcontractor, and they may have passed it down again, but eventually it lands at some point with somebody carrying that cost. And if they go bust, who's going to build your development? So what do you want? Do you want to fight, or do you want to compromise in order to give a bit in order to get the development finished? And that's what we're seeing in a minute. That in a nutshell is what's happened through COVID, and the same principle is applying largely in projects in relation to materials. So irrespective of who carries the risk, the legal niceties of it, parties generally try to work together to try and overcome these issues, whether it's a change in design, whether it's a change in material specification, and if not, the most effective, it's actually many cases the most cost-effective way forward if you add up the cost of, for example, terminating a contract because the contractor is failing to progress regularly and diligently with the works. I'm sacking you because you're not getting your materials on time, because you're not progressing, because A, you can't get them, or B, you can't afford them. And then they're going to go out to the market again, they're going to tender. and that tender is going to come back a heck of a lot higher than the one the contractor entered into at the minute. But that doesn't matter because I've got the legal right. So I'll go and I'll finish my development, and then I'll get my balance of accounts done. And I'm going to go back and I'm going to sue that first contractor for the extra overcost of finishing the development because it has breached a contract, because I'm right. But he didn't have any money in the first place, which is why he didn't do it. So you're actually chasing an empty pot, which is why that sort of analysis is what leads to the conclusion that sometimes it's better to give in order to receive. And number two, consideration should also be given to whether there is scope to amend the design or substitute materials. That can be in both parties' interests. I've just covered that really. And then the current contracts, check as well to see if you're in that situation, do you have any bespoke clauses that might impact upon the entitlement? COVID clauses or Brexit clauses, they started to really come in around about the period from March 2020 onwards. They were being drafted into contracts. And another thing is, remember that that what we're saying here about contracts also applies to subcontracts, especially, and there's a risk that in a supply chain, if they're not back to back, you can find that effectively there is no ability to recover material costs up the line, but perhaps you've got an exposure down the line, which could even further compounds the situation that the main contractor's in. It's just a difficult situation all round. So what are we seeing in contracts then in terms of the next slide? We're seeing a pragmatic approach, and that pragmatic approach kind of developed out of COVID. We saw an industry coming together to work to resolve all of these issues in COVID, and that's been ongoing through the materials and labour issues. But when you tend to find that whenever parties start to stop and become entrenched, is because they've lost money through COVID. They've had to pay for extended prelims. They've had to pay for additional welfare, and now they're hit again with all the additional costs, and perhaps the reserves have run out, and now they've no option but to fight. So what are we seeing? We're also seeing new relevant event and relevant matters, and these are the sorts of clauses that you're seeing. Constraints upon the availability of materials and goods for the works and equipment required by the contractor to carry out the works, which the contractor has taken all reasonable steps to avoid or mitigate, to the extent such constraints are caused or contributed by the default act or omission of the contractor or contractor's person. So effectively, you could get an extension of time, or you could get a relevant event based on the wording of this. The first one relates to materials, the second one to labour. Provisional sums I'll come on to in a minute, and works packages. We are seeing more flexibility about the substitution of materials because people want developments done. Their money's available there, there's investment. They want to get their care home or whatever it is built and generating an income. They're not really interested in fighting. And value engineering, i.e. finding another way around. If the costs are more expensive, the budget's gone up, how can we do this more cheaply? And the next slide is the provisional sums, right? It's a really interesting concept, this, because effectively what you've done is what you're doing is you're saying, right, there are certain elements of these works that are going to be subject to such price fluctuations and such price increases, and labour affected by labour potentially as well. But it's mainly driven by material costs, that I'm going to carve these out of the contract and I'm going to designate them as a provisional sum, i.e. the employer pays whatever the cost is at the time, whenever they're instructed. So it's almost like a wee mini cost plus part of the contract. So what you do is you identify listed suppliers or subcontractors to tender. You identify your package, whatever that's going to be. You identify who you're going to go to tender on. The tenders are returned to the employer's agent, the contract administrator. Remember, not to the contractor. And then the contractor's got to ensure optimal value is achieved, and the tender is conducted on an open book basis. Complete transparency, because the client needs to know exactly that is the best price they can get. And then the contractor then recommends their preferred supplier or subcontractor, because they're ultimately going to take responsibility for it. It's just a process to get the best price. And then you've got an on cost that you're given to the main contractor for the cost of delivering that part of the project. So we're seeing that being identified, some elements of the works. The next thing we're seeing on the next slide, please, is two-stage tendering process. We've got clients, contractors who will not enter into anything that's not a two-stage tender process at the moment on large projects, because it just seemed to be too high risk. You've got pre-construction service agreements, which are drafted with the aim of involving the contractor, early contractor engagement in the project at the design stage. And why do you do that? It was typically so that you can learn from the contractor, so they can show you different ways input into how they would build it. So buildability, programming, how you would sequence the works, construction risk, works packages, interface issues. Effectively, the party that's going to build it, in all probability that you're going to build it, having input into what's the most efficient way of delivering this project. And that allows the contractor time to select and finalize pricing with the subcontractors and suppliers, because they know exactly what they've had input into how it's going to be done. And it says there, if you have the opportunity, ask employer clients to consider this, because there's 2 stages. This definitely, now it does come at additional cost, but it does tend to reduce the risk going forward at the delivery stage. So remember, these are all increased. This is all what we're seeing at the minute, and this is how the market's responding to it. Advance payments an issue as well, because if you're a client, you may want to give the contractor more money to pay for materials sooner, so that they are bought, prices fixed, and they're ready and available to go with the project, because you don't know how much they're going to cost by the time it comes to actually procure them in line with the program. And that's just this cash flow required to cover initial expenses by the contractor, supplier, service provider. That's, or for example, ordering materials with long lead times. You have to consider the intention. If you're doing this, you're basically, this is freestyle drafting this. This isn't a standard form provision. You've got to consider the intention of the parties and draft it accordingly. Is interest going to be charged? How does the contract deal with repayment? If you don't actually go ahead, you terminate the contract. And restrictions on how it's to be used, because you just don't want to give them free money, the contractor free money. So there is a mechanism. I suppose the point from this is there is a mechanism to address forward purchasing of materials as a way of reducing risk. And quite often they're backed up by advance payment bonds, and that's what an advance payment bond is, as a guarantee in the event there's a default. So I'm giving you advance payment, and you don't pay it back to me. So it protects the payments made by the contractor up front. It's regarded as a substitute for cash, and the beneficiaries will generally prescribe an on-demand instrument, a bond, and which will then, if there's a default in paying it back, the bond pays out. But it comes at a cost, and bonds are difficult to get and expensive at the moment. And contractors are always complaining. Quite often they will have a threshold of as to how much they can, what the value of the total value of all the bonds they can have out there at any one point in time are. So contractors don't give them too willingly. But if they're getting an advance payment, you end up in this situation where they're saying, well, it's you the one that wants to buy the materials early, so therefore it's your risk. As against saying, well, I'm giving you money earlier than I ordinarily would in the contract. The next thing is our drafting team are really busy at the minute with off-site material agreements, and that's effectively buying materials as a mechanism for buying materials earlier and having them stored off-site until they're ready for delivery to site for installing into the project. Just check my time, I'm okay. So that's again, it's driven by pressure to secure pricing for materials up front, place orders, and the employer pays for the materials even though they remain off-site. And if you think about that, that means that the next first issue is, well, when does legal title pass? Am I just giving somebody money for something that I'm never going to get back again? So this agreement is intended to address that. So you need a properly drafted agreement for this. And the principle is that in Scotland, legal title doesn't pass to the employer until the materials have been delivered to site and incorporated into the development. So what this is an agreement where the parties are saying that the title is exchanged effectively upon the payment of the payment of the monies. There's a contractual obligation to store them in a particular place on site, to ensure them whilst they're there. And quite often they have to be, it will always say that materials have to be stored separately from all of the materials and clearly marked. And the idea is so that if there's an insolvency of that subcontractor, so that it's clear to any liquidator going in that they don't own those materials are owned by the client. So an off-site materials agreement documents when the title passes, the marking of the products and the materials, inspection rights and insurance obligations, because it is important that you have the right to go and inspect to make sure that they definitely are there, because it is a risk. It's a big risk for the client, and it can be tripartite. Quite often is, and it's palatable to banks also. So it's something else you could consider as in your role in recommending to solutions to clients. And lastly, is you're going to say yes, but there are fluctuation provisions in the contract. They're not used. That's the reality. Is I haven't in 20 years I've never seen fluctuation provisions used in the contract. They're there. Why not? Because prices go down as well as up, and that's the main driver why contractors don't use that provision. So with SBCC fluctuation provisions are there. It's if the contract particular state that they apply, then the contract sum can be adjusted in line with price increases. You have 3 options, A, B, and C. And option B is labour and materials cost and tax fluctuations, and that adjusts it by reference to what the market conditions or market prices were at the base date. And remember, again, that's the importance of always having a base date in your contract. Of the materials, goods, electricity, fuel, or any other solid, liquid, or gas necessary for execution of the work. So it does exist that you can use it as this, to some extent, as the simplest way of doing it, but the inverse also applies. Should the cost of these materials, etc., fall, then contract sums lowered, and contractors are not keen on that. You can also draft bespoke fluctuation provisions. Some of the things we've seen actually over the past few months are, one example is we've got an M&E contractor where the price of copper has only been held for 1 day. So he's tendering on the basis of something that by the time the tender is submitted and received, the supplier isn't holding the price anymore. So it's a very volatile market at the moment. It was just like the very first slide we talked about sort of this wood, concrete, copper, probably the 3 most common ones we've heard about. And that's, so if you're to take all of that, what's the message, the takeaways from all of that? It is that the construction industry is badly affected at the moment by materials. It's going to get worse, and I think given the events in Ukraine at the moment, all suggestions are the price of fuel is going to go up as well. All of these costs will increase. There's limited routes to recovery for a contractor under the contract. You need to watch as contract administrator, if that's the role you're performing, that you're aware of what the entitlement is, and be wary of issuing instructions where they're not needed, because you could just open up an entitlement that doesn't exist under the contract. But there are at the same, that's protecting you / protecting the client. But at a practical level, what's actually happening, we've listed the things that are going on, because ultimately, do you want to fight for 1.5 years, 2 years through the courts, or do you want to, the developers quite often are just making concessions in order to get, I think so long as there's an open book approach and an honest approach by the contractor where they get complete transparency of where the price increases are and satisfied that there is no alternative in terms of a revised specification, a different supplier, a different design, developers are looking favourably on having to make adjustments or concessions. So we are drafting a lot of settlement agreements based around that. But aside from that as well, there are other mechanisms that are being used that we've listed there, such as off-site materials agreements. That's my bit finished and bang on time. So any questions?
Thank you, Manus. Thank you, Stephanie.
All right, thanks.
If there is any questions, you can pop them into the chat box and we can cover them. If anyone's typing away just now, I thought I would ask a question to Stephanie based on the structural movement of the high-rise case that you're talking about. Although the engineers weren't found liable for against the reputation of the contractors, were they trying to cover costs for anything else, or was that all that they were looking to recover?
Yeah, they were looking for costs beyond just reputational damage, but the court was just asked a certain number of questions by the parties, and that was one of them. So there wasn't kind of any judgment determining whether or not they were going to be found liable for the remainder. And one of the kind of interesting points that the court had raised is, why wasn't time bar more of an issue in this? Because as I said, that development finished in 2005 and they didn't discover the damage until 2019, which, given you have 6 years in England and Wales, 5 in Scotland, for kind of raising a claim to recover losses as soon as you have become aware or could have become aware of it. It was one of those claims where you'd have thought time bar would have been more of an issue, because the way the case law is going at the moment, it's become very difficult to argue later dates for time bar triggering. But anyway, that was just an aside. So no, we didn't get kind of a fuller answer on it, but it seems it would have been, I think, surprising if they'd managed to get recovery in that claim overall, given the key time bar issues. But that's just another legal nerd point.
Thanks for that.
That's fine.
I don't see any other questions in the chat box. So I think on that note, we could round up. We're pretty much just on time. But thank you very much, Stephanie and Manus.
No problem. I think
I
you'll probably
suppose
get a copy of the slides. So if there's anything that occurs to anyone, feel free to email us.
Have our contact details on them.
Yeah.
That's perfect. And like I said, this presentation will go online as well. So if anybody's watching back, they'll be able to see your information as well if they want to get in contact.
Yep. Fab.
Okay.
Thank you very much for your time.
Thanks, everyone.